Court is composed as follows. Today is the 23rd of August 2017. Presiding over a court is Mbaledi. Public Prosecutor Mr. Nobela. Interpreter Mr. Mkwenya. Stenographer Mr. Dogo. Case before court for the continuation of a trial. State as less evidence in chief of one police officer, Mr. Mtetra, and was cross-examined by the defense. No examination was done by the state, and the worship state is no longer proceeding according to the remaining witnesses, which are two. Sorry.
Mankis and Nkosi. No, Regional Court 1.
As the court pleases your worship, I do confirm our appearance on behalf of the accused, your worship. As the court pleases your worship, at this stage, your worship, the defense will move an application for discharge, your worship, in terms of section 174 of the Criminal Procedure Act. Your worship, the state only called one witness, the police official who effected the arrest on the day in question. Your worship, I won't be long in terms of this application. However, your worship, everything is clear in regard to this matter and the evidence before court. Your worship, my client is facing a charge of possession of drugs, your worship. And your worship, this element, this crime, your worship, have certain elements for which the state needs to comply with for them to prove the case. In this instance, your worship, all the elements of this crime were not satisfied by the state, your worship. Your worship, the third element, your worship, the first element will be the act, that is possession or use. Your worship, the state evidence does not show or does not comply with this requirement, your worship, when looking at the evidence of the state witness. The second element of your worship will be that one of a drug. There was no evidence, your worship, to prove that the accused was found in possession of drugs. The third element, your worship, will be unlawfulness, your worship. On the unlawfulness thereof, your worship, the same submission as the first requirement, Your Worship, I will employ the same. The last one will be the intention to possess, Your Worship. No intention was established by the state because there were 3 occupants in the said vehicle, Your Worship, and it is my submission that the evidence led by the state did not show that the intention to possess on the part of the accused. Your Worship, further I will refer the court, Your Worship, to the case of State Enshrined Prakash Diwan, Your Worship, which is the Western Cape Division High Court, Your Worship. The judgment was delivered on the 8th of December 2014 by the Deputy Judge President, the Honorable DJP Traverso, Your Worship. Your Worship, in this case, the legal position, the current legal position, was briefly stated by the learned judge as follows, Your Worship, in paragraph 15, Your Worship, wherein the learned judge stated the following: A, an accused person is entitled to be discharged at the close of the state case if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. B, in deciding whether an accused person is entitled to be discharged at the close of the state case, the court may take into account the credibility of the state witness, even if only to a limited extent. C, Your Worship, where the evidence of the state witnesses implicating the accused is of such poor quality that it cannot safely relied upon, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for discharge should be granted. Your Worship, it is my submission that in this matter, the evidence led by the state witness is of such poor quality, Your Worship, that any reasonable court, Your Worship, may convict based on that evidence, Your Worship. And Your Worship, putting the defense of the accused in his defense, Your Worship, it's still my submission that it won't supplement the state case in any manner, Your Worship. Your Worship, it will be a waste of time, Your Worship, to extend my arguments, Your Worship, because it's my submission that it is on the face of it, Your Worship. The state, they failed, Your Worship, to put a prima facie case against the accused, Your Worship. Only one state witness was called, and it is my submission and my request that his evidence be thrown out of the window, Your Worship. It does not make any case, Your Worship. And in relation to the credibility of this witness, Your Worship, I will also request the court to take into consideration their credibility of the witness, Your Worship. Your Worship, further, I will refer the court to State versus Mpeta and others, 1983 decision, volume 4, Your Worship, essay 262, where, Your Worship, it was held that relevant evidence can only be ignored only if it is of such poor quality that no reasonable person can convict. It is my submission, Your Worship, that in this case, if the court assess the evidence as per the state witness, Mr. Mtetwa, it is my submission that his evidence is of such poor quality, Your Worship, that I will request the court to ignore it and throw it out of the window, Your Worship, as the court pleases. Your Worship, further, Your Worship, State versus Lubaka goes on, Your Worship, to state that putting the accused to the witness stand, Your Worship, will be the violation of his constitutional right, Your Worship, to remain silent and not to incriminate himself. Your Worship, in this case, I will not dwell much on my arguments. I will, however, request the court, Your Worship, to accord the accused the benefit of doubt and acquit the accused at this point in juncture. Your Worship, the prima facie case was not placed. Your Worship, the procedure in these applications we do not require that there must be no evidence at all. However, Your Worship, there must be a minimal evidence, Your Worship, that will put the accused in his defense. It is my submission that in this case, there's no minimum evidence. The state failed to meet the required threshold. Therefore, I will request that the accused be discharged at this point in time, Your Worship. Your Worship, I will not go back to the evidence by the state witness because it's on the record, but it's still my submission that no any court or reasonable person may or can convict on the evidence led by the state witness, and I request the court to throw this evidence out of the window and discharge the accused in terms of Section 174 of the Criminal Procedure Act 51 of 1977. As the court pleases, Your Worship, that would be all from the defense.
Your Worship, it is the state the court that up in the TO, when I consulted with the state witness, the interpreter, and the others, the state established that indeed there was a charge that is going to be preferred. It asked possession of drugs, to be particular in this case cannabis. Your Worship, it is quite well known, and the court decision is in existence in this regard, that although cases coming to the fore before the prosecution, but the duty of the prosecutor should not be to seek and secure conviction at all costs, but in the state thereof, the interest of justice should be served. Even if that goes to an extent of revealing information which is detrimental to the state, but supportive of the accused version. In this instance, Your Worship, there is no doubt that the officer who came before court to give testimony, according to him, he had information that there was a person with substances which were alleged to be drugs. He followed the said information, and the car that was described by the informer, then the car was stopped. The problem that the state had with this witness is there were 3 occupants, and the 2 occupants pointed to the accused as the one that possesses the said substance. Based on that information, the officer arrested the accused alone, leaving the two. More to it, Your Worship, I'm very appalled, very perturbed, is that the officer said he was not accustomed to search, yet he searched the accused. So it did not make any sense how on this earth the police officer cannot have power to search anybody whom is suspected to have committed an offense. I was so perturbed about that shred of evidence coming from the police officer. And the fundamental basis of arrest, the explanation of the rights to self-determination, that was not done. Yet he relied on that information and come to court and tell the court that he based his arrest on that information. So, Your Worship, the state has decided not to call further witnesses because already with the evidence before court, many violations have been done. And it is up to the prosecutor to bring that to the fore. And that was also explained to the witnesses, that this is the problem which has been created by the witnesses. So there will be no need to call any further witness because they were not going to take this court any further. Your Worship, so with these words, the state does not object to the request by my learned colleague, and as a result, the court may decide to grant a section 174 of the Criminal Procedure Act, 51 of the 1977.
Is an application for the enhancement judgment and section 134 of the Criminal Procedure Act, with one of the second offense under the law, with an actual right that application to be charged in terms of and the state also addressed the court and that does not make any objection to charge in terms of section 134 of the Criminal Procedure Act. To be granted the figure of
Nasikibas mumuge mu lestoro ke semelo akoge ingandolo ke usi idale na lungu lo shogo sisi na ayo ana ki lestoro ke semelo ko to kishelo ke na pan ke to la kala ni na sala wa bega na kisa to inda asho.
The provisions of section 174 of the Criminal Procedure Act provides as follows that if at the close of the case for the prosecution at any trial the parties of the ordinance that evidence by the accused or the tender offense objected to the judge or any offense of which may be convicted on the judge it may return a verdict of guilty.
Ushojalo mthetho uma ngabe lo muntu sosebenza ke uthi ke ngalokho kubonakala ukuthi ngoba amnasisindo se ingandolo ngene kulungile ukuthi ke isikhawo na onakala ke uyekhaya
law that the word no evidence must not be no evidence at all, but rather no evidence on which a reasonable court acting carefully might conclude.
Umthetho wethetho lesemacala lokuthi nabathi-ke ukufakaza basho ukuthi ukufakaza phambi kwentando ede basho ukuthi nokufakaza ngaphambi kwentando akunaso isimo esibadedelayo ukuthi ukufakaza kona.
And whether or not to refuse or to grant a discharge at the stage of a trial entails the exercise of a discretion by the trial court, and they may return a verdict of not guilty and discharge the accused there and there, or it may refuse to discharge the accused, thereby placing him on his defense.
Lokuthi-ke uma ngabe kungekho lo mfakazi lobo inkantolo-ke kumele kufanele ithathe isinqumo ukuthi iyekele uqhubeke ekhaya noma ithi cha wena-ke uvekele uqhubeke ukufakaza isindlela lakho ngehlala.
And it's also stated in the State versus Matilda and others 1997, volume 1 SACR 10 WLD, as it's stated by Judge Klassen, that in exercising a discretion in favor of the state under the circumstances of the case in terms of Section 174 would, in my view, deny the accused his right to a fair trial.
So icala leli-ke lamathebula leli kakhulunywa-ke ngaphambilini lana-ke jaji-ke sesingasho ukuthi-ke uma ngabe-ke lo mfakazi-ke zingekho bese wena awusakhululwa lokho-ke kutabaseke sekumuka lumelo lakho lokuthi-ke uthole-ke ukuthi licala lakho likhulunywe ngalokukhulu-ke ukushesha nekulokhu-ke lokusebaleni.
And the spirit, the purpose, and object of the chapter 3 of our Constitution can lead to no other conclusion but that the concept of a fair trial in these circumstances means that one can justly and fairly say to the state, you have a chance to prove your accused guilt. They prove the accused guilt. And you failed a prima facie case against the accused. Now you cannot seek the accused or the co-accused assistance to do what you are supposed to do.
Ukuthi-ke uyasho-ke imithetho-ke esisekelo ukuthi-ke uthi umbuso unikethiwe isikhathi nawo ukuthi kufakazi kutholakala lemicala akusiwo-ke umsebenzi wakho njengembangalelwa noma ke lomunye-ke loboshanayo ukuthi atonceda nje umbuso ukuthi utholakale ukuthi ube nobufakazi onesisindo esiphendulayo.
As it is also stated in the State versus Langamantla and others 1991 volume 1 SACR 391 WLD as just Wills held as follows, that it seems to me that the provisions of Section 35 subsection 3H of our Constitution with regards to the presumption of innocence, the right to silence and the right not to testify have at least three practical consequences impacting upon Section 174 of the Criminal Procedure Act.
Lowo mthelelo-ke wawo lamalungelo akho ukuthi-ke ubize-ke ungasho lutho ungakhulumi-ke lutho-ke kuwo-ke uhlukile-ke nokulumela umthelela kuso lesicelo lesi sekuthiwe kakhulu-ke ngaphandle-ke utholakala kwemali.
However, at this stage, this court will only going to focus only on two aspects of such that the court has a duty merit to raise the issue of the possibility of a discharge at the close of the case for the prosecution, while it appears to the court that there may be no evidence that the accused committed the offense.
Nokuthi-ke inkantolo-ke itakuwa-ke esindlela esibili sekuthi-ke ibuke yona ngekuyiyo ukuthi-ke ngabe sikhona na ubufakazi loba-ke abukho ukutholakala kwemicala noma yokuthi
And where there is the credibility is of such a poor quality that no reasonable person will possibly accept it should also be taken into account at this stage.
Nokuthi-ke lokufakazi okuthuliwe-ke ayikho-ke umuntu noma-ke umuphi-ke lapho uyisisile kangathola ukuthi unecala ekubweni kwefakazi okukhona.
As the panel stated in the State versus Lubaka 2001, volume 2 SACR 703 SCA fact it was held that if there is no possibility of a conviction other than if the accused and incriminates himself, a failure to discharge an accused in this circumstance would be a breach of rights granted by the Constitution. And the concept of a reasonable possibility of supplementing the state's case implies a state's case that can be supplemented. And if there is no chance that the demerit of the state's case can be overcome by the defense evidence, there can be no question of placing the accused upon for this purpose. A mere possibility that the state's case may be supplemented does not justify the refusal of an application for a discharge. And here a reasonable possibility must exist that the evidence will come to light during the defense case, which may implicate the accused and create a factual basis upon which a reasonable person which justice could convict the accused. As it was further stated in the state versus paper, that Williamson held that relevant evidence can only be ignored if it of such poor quality that no relevant would possibly accept, and that credibility therefore plays a limited role at this stage of the proceedings. And at this stage, I'm not going to repeat of what the witness has just said, as there is already before this evidence. The evidence that is tendered by the witness was of such a poor quality. He was not such an impressive witness. And at this stage, this court will be first as what as the state, and that application for discharge in terms of section 174 of the Criminal Procedure Act of 1976.
As the court pleases your worship.
As the court pleases.
Number one.